9:30, so I think we can start. Tom Marcus with the city.
Lori Carnahan, Human Resources.
Doug Green, Fire Medical.
Sean Coffey, Bid Chief, Interim Fire Chief, Fire Medical.
Jason Williams, Local 1596. Aaron Payne, Local 1596. Dean Garrison, Local 1596.
Seamus Alberton, Local 1596.
And our guest?
I'm busy
Jason.
You're a guest.
Dylan Brown, Local 1596. Charlie Biggerstaff, Local 1596.
Welcome. Okay, Dean, please
Yes,
do
sir.
the honors.
Opening statement. The purpose of these meetings is to discuss issues concerning wages and/or fringe benefits and/or working conditions between the City of Lawrence and the elected representatives of the International Association of Firefighters, Local 1596. Pursuant to Resolution 6817, these discussions are to be open to the public unless it is mutually agreed to have them closed to the public. However, there will be no public comment during these discussions. Observers are expected to remain silent and are asked to silence their cell phones. Proper decorum for a business meeting shall be observed at all times. Anyone who disrupts the meeting will be asked to leave. Ground rules have been previously agreed to by both parties. The city manager and the president of the International Association of Firefighters, Local 1596, will co-chair the meetings. The city and the IAFF shall designate a backup co-chair for the meetings. These meetings will be recorded and posted to the city's website.
Thank you. Next is the exchange of materials, if any.
I had a couple of data items
Yeah.
that I sent out last night. Is that good?
Yeah.
A couple of meetings ago, I had indicated that, that I would look into the overtime requirements at other agencies, because we'd had some discussion on it. And our compensation analyst, Corey, made some email contacts and recorded their responses. In us reading through it, it seems a little rough, but I thought I'd just pass out what we have, and if we want to organize the material a little differently or make some return phone calls, we can on that. And the second item, and I think this is the last of the items that I had made a commitment to do some research on, although we could slice and dice things differently if we wanted to. We had some discussion on the wellness program, and I think some way to comment about what is the sick leave utilization. With the department, so I had some people in my office pull some data. This one is very aggregate, and I know last time or the time before we talked about how the aggregate may be not perfect. So I can accept that statement. But what I have here is a list of the sick leave usage, and we have something called the combined register in payroll, which is just totals of every pay category that we have, and it's totaled by department and divisions. It's not totaled by job classification. So I asked the staff in my office to go back for a long time and look at sick leave utilization, and we just did the fire department because I didn't have any other way to break it down. Fire department sick leave utilization and everybody else in the city utilization, and then took it as a percentage, because you know the annual hours are different. I took it as a percentage of total hours, and my calculation for that was FTEs assigned to the department and to the city at that point in time. So as the city grew, which we've done over this period of time, the FTEs were allocated, and I realized that I did the entire fire department by 2912, and not everybody does 2912, but that would turn, I also did it with 2,080, and it is to the benefit of the calculation to use 2912 for everyone versus not. So I do realize that that's also an assumption in order to just get something on a piece of paper. So those are the first, well, the year is the first column, then the second two are the city and the fire department, and then the difference between the two, and the math there is fire to non-fire with that. And then I did the same thing with the difference of year over year. So as you can see, the first year doesn't have a number because it was compared to the year prior. Did the same thing year over year, and then I did the same thing with the wellness program, because we had some discussion on the purpose of the wellness program, whether it was an effective program, not an effective program. And I did the same, using the same methodology with the wellness hours. And so there is a percentage of the annual hours, not counting overtime and that sort of thing, but base hours for the city and then for the fire department. It did not turn out well, as you can read the summary at the bottom, and my conclusion, based on reading all of those things, that over the course of time, and as you can see, the program started in 2001. Those first 2 years are grayed out in the far right-hand column. Since the beginning of time, this program has not resulted in the reduction in utilization of sick leave, if that was the stated purpose. In fact, both have increased over time, and they have increased at a greater rate than other city departments on that. So I would be happy to have some discussion on what the purpose of wellness is, but this doesn't lead me to believe that we're really attaining the purpose that I always thought it was designated for. I'm not,
You done?
yeah. And then at the end of the meeting, the future agenda.
What I might suggest is that you folks take a look at this, take some time and go through it. I would tell you, you know, we're the subject of surveys and analysis all the time. And, you know, it's not always conclusive. And I think even Lori's comments, I think, have a degree of subjectivity to them. So what I would suggest you do is take a look at it and maybe give us some of your thoughts. Now, I suspect that you could have some rare sickness issues that occurred during some of those periods of time that could lead to that. But, you know, when you look at a snapshot historically, there's always mitigating factors one way or the other. So please take a look at it. Let us know what you think. Let us know if there's some aberrations that may have existed during that period of time, but we'd be interested in getting your feedback on that, so.
I have a quick question. It says it's not working for the fire and medical. With the same chart, is it working or not working with the non-fire?
Oh, I don't know as it's an effective program all the way around. I just made that comment because that was the topic of our discussion.
So it's not working for non-fire employees either?
Well, I would say that sick leave has increased also, well, sick leave actually over time has increased for both, not as much for other city departments. The average is kind of where we started out over time, but yes, sick leave has increased for both city and all the way around. And so why we would use this program, if this program is truly designed to reduce the use of sick leave, I'm not sure it's accomplishing that goal citywide or within the fire department, and I think it's worth examining what is the purpose of that time off award, and should that purpose change, should it not be here? I mean, I think this is a statement that I'm not sure that we can draw a parallel anywhere in the organization for it being effective for that purpose.
Lord, no questions. On this last, column, the wellness hours used, How do you feel that would look compared to wellness hours reported?
There's,
You see what I'm saying?
there,
Like,
there are,
maybe we're not using them as much, but we are being awarded the wellness hours. Is
There
that a
could-
concern or
uh,
possibility?
whatever is currently in the bank would be hours, I guess, awarded but not
But
used.
not used.
It does have an annual limit. The programs, all three programs that we run have an annual limit that's very low. And so in order to continue to earn hours, you have to use hours. So there is a slight difference. There are a few hours that are sitting in banks right now, and maybe more than a few. It could be up to plan maximum for those eligible to participate. I did not look at that, and I could bring that back to find out what the balances are that we all currently carry. But the hours that are currently there today are the only ones that would have not been accounted for in some year in this chart. And so those are additional hours earned but not yet used.
And then the second is just, maybe just your opinion, but on the difference in sick leave over time, it showed an average of 0.06%. Do you feel that
That's
is
kinda-
a high number, a low number? I mean, I don't think for that too, so I don't know.
That, I will tell you, there's not a lot of data out there on average sick leave utilization nationally. And so that would be what I would want to compare to as to whether ours citywide or in this department were appropriate or not appropriate. I do know that years ago, 2%, and I'm talking years ago, 2% was a national average for sick leave utilization. Now, I guess we have to realize that there are companies that don't have sick leave, and when you're sick, you're fired, which doesn't happen in organizations like ours that carry sick leave balances. So that's probably not in that 2% national average. And then a lot of people who work in exempt from FLSA positions throughout the country don't have time off balances. They just have job assignments, and they take time off when they can or when they need to. And you don't track hours. And so those people would not fit in those averages either nationally. So I think we are on the upper end probably of sick leave utilization nationally. Municipalities tend to be that way because we have these generous programs. So I don't know if we're out of line for other municipalities.
I think clearly, from the management standpoint, we want our employees to be healthy, we want them to show up to work. I think likely the wellness program was put in place to encourage healthy living practices that our employees follow, so that they can do that. I mean, the reality is I'd prefer to pay straight time. I'd prefer not to pay time and a half or double time for an hour's worked. That's not accusatory. That's just a fact. We want you to be healthy. As you all get closer to retirement, such as I am, you'll realize that you're not gonna, all the work you did to accumulate a pension and everything else that you earn isn't gonna be worth much if you don't stay healthy. So it's to all of our advantage to make sure that all of you are healthy, not just during your career, but for your post-career too. So if we look at the wellness program, we need to have some sort of assurance that it's actually working and keeping you healthy. Use of sick leave may not be the only performance indicator whether it's working or not. And that's why, I don't immediately accede to that conclusion. And that's why I want you to take a look at it and, give me your thoughts about how we can improve that situation. Clearly, it is to all of our benefits to keep you all healthy. Less insurance claims, more work days that you perform, less callback that I have to pay people on overtime. All of those things, from a manager's standpoint, are what we're trying to achieve. And we need to do that, quite frankly, in tandem, not separately. So, take a look at it, let me know what you think. If there's other programs, quite frankly, that are out there, when you talk to your other colleagues in other departments, where they can show that it's actually worked, we'd like to hear about that. It's to our mutual benefit. All right. Anything else you want to comment on the distributed materials?
That, no, unless you have some comments on the other handout on the overtime, which, is a,
Is an
I think
analysis of what some of the comparables are. I understand, unlike the LPOA, they have a fixed list of comparables.
mhm.
And we have, I think we pick and choose based on, relevancy, I suppose, to a particular issue or whatever. I don't know what the criteria is, but I think you've used some that show up pretty consistently.
Yeah, these are the ones that we had a discussion with in 2005, with the comp study, and that I think we, as a group here, have used some of them, we haven't used all of them from salary comparisons, that we've used in the past. We haven't got a response from Olathe, that's why it's blank, and I think these are people that we regularly contact from our office that's why I picked that group. These are probably cut and paste from their emails returned to us, so they are organized, they're all organized differently and answered a little differently, because it's probably six individuals writing their own responses. And so we can do more with this if we want to, but this was a start as we had explored the overtime calculation for, and I think the specific question was hours worked, what goes into hours worked, that technical term, hours worked, for the purpose of calculation eligibility for FLSA overtime. For that.
Do you have anything to exchange, Dean?
No, sir.
Okay. So if that's the end of the discussion on exchange of materials, we can go into old business. We just thought we'd go through the remaining items that are listed on our agenda. If I read this correctly, the first item is Article 10, Section 10.32? Okay.
Hey, Tom?
Yeah.
Is it okay if we back up for a minute and talk about 922 apparatus maintenance?
Sure.
I think we only briefly went over it yesterday, or excuse me, Monday.
It's not, what page is that? It's 43?
52, I think. It's section 9.
42.
Yeah, it's on page 43.
Okay. So, just trying to understand the city's perspective on this issue, that you guys feel that it is the current language is a violation of the resolution, correct?
What's that?
So apparatus maintenance, there's two sections here. I think it's fair to talk about both of them together. The first one saying the employer and the union agree that the health and safety of employees is a priority and that every effort shall be made to provide safe and proper efficient working equipment. The section following it just says apparatus found not to meet safety standards shall be taken out of service until such repairs have been made. No equipment or apparatus shall be placed into service without having received the approval of the fire chief or his or her designee. The city is proposing to eliminate these sections because they are a violation of Resolution 6817.
Right.
I was curious to let me back up. When you guys have listed that your management rights in some other sections, you've listed the particular management right. There's not one listed here, and I was wondering if you could point out to me which one you guys.
It's section 5F.
F. Okay, so which language in particular is keeping the fire chief or the city manager from determining the methods, means, and materials or assignments in this MOU?
Well, if you go back to the general language, it says, however, the following topics are considered management rights are not subject to discussion.
Okay, so you're not willing to discuss the current MOU language?
I'm making the point that the management rights clause basically says those matters really aren't subject to negotiation. Even though they've been embedded in the agreement, I think the management rights clause is very clear. And this is the authorizing document that
Mhm.
establishes the relationship to negotiate.
I agree it's fair that that's what the resolution says, but where in particular do you feel this language violates or infringes on those rights?
I think it's exclusively the management rights, and in this particular case, it would be the fire chief.
Okay, so
With
this
the
language limits
command.
the fire chief's ability to make a decision how, I guess is what I'm asking.
I think it's entirely their exclusive ability to make that decision. And so by adding
Which,
other language to it, modifies that, which I contend is contrary to this language about management rights.
which decision, though, is being kept from the fire chief's hands in this language?
It says it's not even to be discussed. This is way beyond discussion by ensconcing language in an agreement that says these other provisions are added to it. At the
Okay.
same time, I would say to you, Seamus, a good manager is gonna talk to the employees about these issues.
Thought-
But
Go ahead.
But I would say that it is their exclusive right to do this. So that's the difference I'm pointing out.
Okay,
I contend that when this was drafted, this was contemplated, that those weren't items that were going to be bargained or were intended to be bargained.
So
And I
I-
think that's what this does by putting that language in the agreement.
are you suggesting that the firefighters don't have a right to negotiate items of safety?
I'm saying that the determination on a purchase of equipment, the stations, come back to the management of the department. You certainly have a right to express your opinion about the safety and everything else to this fire chief and the command officers there, but they're the ones charged with management of those decisions.
Okay,
And I would expect and hope that a good manager is reaching out, but I don't see that as the same thing as ensconcing language in a labor agreement.
okay. Well, I think we're gonna have to talk about this further, because it seems that you're unable to specifically say which decision the fire chief is being kept from in this language.
The bar is extremely high. It says we're not even supposed to discuss it. Now we put it in writing.
Again, I'm asking specific language.
I'm saying,
I think he said it. I don't know how he could say it any more clearly. If you read section 5 in its entirety, it's, as he said, not a point of discussion.
And the city feels that taking a fire truck, an unsafe fire truck out of service is an item that the firefighters are not able to negotiate for.
no, I
The
don't think,
safety
I
standards
don't
are
think you should
non-negotiable.
negotiate that. I think what you should be doing is reporting it, and the authority and the responsibility for taking out of service rests with the fire chief and the command
So
officers.
then the city feels that safety standards or a safe working environment is a non-negotiable item. So in a
I'm saying it's the responsibility of the management of the department. That's what we pay them for.
So safe
and-
working conditions are the responsibility of management, not a negotiable item?
That's my view.
Okay. Thank you.
That does not mean that I don't think you should be communicating concerns about safety to the management, but ultimately, the management has the responsibility.
So what
To
you're
make the
saying is that
decision.
firefighters have no right to negotiate safe working conditions.
I think there's a list in here of what's negotiable.
We can parse words all day, Seamus.
Okay, let's move on.
All right. So, section 10.32, I think the only significant change in that particular section refers to the change in the name of the duty from light duty to modified duty. Next is section 10.5.4. And our view is that the responsibility for determining day-to-day fitness rests with our city physician. And then we further added, all fitness for duty criteria shall be based on NFPA 1582, but shall be in accordance with any applicable Americans with Disability Act ADA procedures. And again, the city provides a grievance procedure if in fact an employee feels aggrieved as to the applicability of that section.
Tom, can you speak on a little bit on why we decided to add that ADA procedure, the act, and not some of the other acts, or what were you guys' interest in?
I think one of the staff members suggested that. I'm trying to recall who that was.
Our general process when people are released for duty is that they have a full release to return to work, and if they have permanent restrictions, not temporary while in a healing mode, but when they have permanent restrictions, that those are brought forth, and please add if there's some other legislation that we should be paying attention to. But generally, it's, some of those individuals may be qualified under the ADA, they may not. But we feel like we use, in the fire department, we use the NFPA standards for the standard of what's considered fit for duty during the annual physicals. And then anything contrary to that needs to be discussed. And the only thing that I could recall that comes up in particular besides that is on occasion it might be covered under the ADA. If there's other legislation that you feel is applicable, I think I would love to hear that and talk about including that as well.
Anything else? Okay. Next section is the 10.56.
Or just 10.6.
What's it? 10.6?
Yes,
Okay.
and I think it's on page 53.
10.5.7?
Oh, sorry, we skipped that one, the one right above it.
Yeah, basically, we're claiming that that is a management right decision as well.
Tom, is the city's perspective on firefighter fit for duty mid-evaluations, is that an issue of safety? Do you guys feel that healthier firefighters are safer firefighters?
Well, I think that's a pretty subjective question. What's healthier?
Okay. I'm just asking your perspective.
Okay, section 10.6, is that the next agenda item?
Mhm.
All right. Talks about station fitness. The city will provide adequate fitness equipment for the stations. The equipment shall be maintained in good order, working order with routine maintenance and repairs as necessary. The peer fitness team or any other person the chief deems appropriate will conduct research and make recommendations regarding the purchase of fitness equipment. Chief will make the determination on the purchase of equipment. Section 11.1.2. It's a minor wording change. The IAF shall recommend 6 members to the training program team. The chief shall approve all team members. Section 11.1.4. All recommendations shall be forwarded to the chief with a copy provided to the IAF president. change much. Then the next section, I think that's a broader discussion. In fact, we had a question mark there. So I went and did a little research on living documents. First off, a living document is described, it's also known as an evergreen document or dynamic document. It's a document, and that's, in this context, this living document is what's referred to the whole document. It's a document that is continually edited and updated. Living documents are changed through revisions that may or may not reference previous iterative changes. And it then goes on, and it's kind of an interesting, for us people that get into things like this, there's a constitutional discussion as to whether the US Constitution is a living document or not. And if you pay attention to those sorts of things, that seems to be an ongoing debate about whether it's just within the square confines of the constitutional document, or which means a strict constructionist, or if it's contextual as to, as times change, the interpretation of the US Constitution and how it's interpreted gets changed. You'll recall that a couple of the things that we talked about, and this came out of a discussion initially with the LPOA, was an approach that contextually, I think, after we enter into an agreement with an employee association, you always run into things that are, you know, you hadn't really contemplated all the specifics. And so those are embedded in other parts of the agreement. Specifically, Article 4 deals with memorandum of procedures. Article 6 is the memorandum of understanding, and Article 9.5 is the grievance procedure. And so there's both informal and formal methods to address the contract between the time it is signed and the term that it ends in. I think that's what this tries to do. My most serious objection is more with the grievance procedure as it currently is listed. Not all parts of it, but the part that allows what I term a class action kind of complaint process brings in mediation, but not mediation as we typically know it in the rest of the agreement. Mediation more in the term of binding arbitration. And that's directly different, significantly different than the grievance procedure for all other employees. And I think that it, I'm not really sure how much our city commission understands the difference in that at all. Because in the general grievance procedure for all other employees, we have to transfer any grievance procedure that makes it all the way to the manager's office to the city commission. They then can look at the policy that was being essentially grieved, or its applicability to an employee that files that grievance. They can actually change that policy, and they can change it retroactively. And I think that goes more to this living document argument, consistent with the authorizing resolution that allows us to sit down and have these negotiations. So what I propose to do is to come back with contractual language that addresses this issue. So you will get that. When is our intent to get that to them?
I think we want to bring everything Friday.
So you'll see everything that we have in terms of contract language on Friday. For any of those things that we questioned, we told you what our views were. We tried to engage in what our, how some of the history of this came about. So we will come back with specific language that we feel would modify the agreement in whatever way we're proposing to modify the agreement. So you'll have all of that specific language. All right. Next is section 3.1.2. Is that right? No,
All of 13.
all of the living
Yeah,
documents
all
there.
of the living document was your discussion right here.
Yeah,
All
yeah, the
sections.
grievance procedures available, so I addressed that. And then and it does go on to say in the existing language, and we'll probably parse out some of the existing language as well, that we think is still appropriate. Last item is rights of employer and employee. And what we've said is the city proposes to eliminate this section because neither federal or state law grants this right. National Labor Relations Act excludes from its purview local governments, which is kind of referencing back to the existing language. The city has not elected to be subject to PARA and instead is governed by Resolution 6817, for which the applicable language is contained. One of the things that I think is in here refers to, and I'll read it. With respect to promotions, the city shall not discriminate against any employee as a result of union membership or participation in legitimate union activities. For its part, the union agrees to respect the rights of management outlined in Section 5 of Resolution 6817. Both the city and the union are prohibited from interfering with or inhibiting through coercion or intimidation the exercise of rights of the other party. This language almost comes verbatim out of the resolution. If you go back into the resolution, and specifically Section 8, this is already there. So when you go back into the earlier provisions, preamble and other places, the resolution is stated as to what's governing. So I think it's redundant. I don't have a big problem with redundancy in an agreement, but this stuff is already covered. And I wouldn't want somebody to think that you necessarily had to add this to the agreement. It's already part of the resolution, which is part of the agreement in numerous other sections of this. So I'm not gonna die on my sword on it, but I think that it's been repeated a number of times. Maybe a little more specifically there, and maybe that's something that gives you and your membership, comfort restating it, so. Those are my comments about that, and I think that ends the,
That's everything with the management rights
Right.
section.
right. New business.
This was all of the items that were in our initial proposal that we handed out that are not previously covered in the discussions we've had the last several meetings, and non-economic, which I think, as I understood, the end of our conversation last time was that we were gonna hold the economic items for a common discussion later. So this is everything else that was in our initial list.
Do you want to talk about each of
Real
those?
quick, Laura, we're requesting to caucus following the end of the manager's rights section,
Okay.
and then we can start on the non-economic items.
We want 15, 20 minutes?
Yes, sir.
All right, let's do 20.
Yes, sir.
Okay. You want to go to new business, or,
New business.
okay? Why don't you comment on those, Lori,
On the next section?
in the new business section?
Okay. Okay, the sections on new business are all of those remaining items except for the economic items that we haven't yet discussed, and it starts with Article 10, Health and Safety. And 10.2.1, it's on the right page here. 10.2.1, hold on, not right. That section, the current language is a generic, it's on page 46. The current language is a generic statement on workers' compensation, and the city proposes that we actually cite the Workers' Compensation Act in there. And so we propose it read, all on-duty injuries shall be covered by workers' compensation as outlined in the Kansas Workers' Compensation Act, KSA 44-501. I don't know what that, how do you say that? Thank you, that's sick. And provisions outlined in this section. So we propose we update that.
Lori, did the third party that's now helping administrate work comp, did they have any input to this language?
We just looked up the section that was appropriate and cited it. And then 10.5.2,
So I think the answer is no.
thank you. And 10.5.2, that section, we just proposed that, this is the section that has to do with participation in the annual medical evaluation that is mandatory for all employees, and it says the evaluation will include the following, and there's several things listed under here. But near the bottom on the last four options, under PAP, it says female only, mammogram, female optional, prostate, occult, male optional, PSA, male optional. We're proposing that we remove the gender references on that as cleanup language, that it would be more appropriate just to have the tests listed.
Procedure.
Yeah, procedure listed. And then 5.5.6. There is a discussion, this is discussing record keeping, again, I think under work-related injuries or the annual fitness exam. And under that, there's a discussion right now about record keeping will be conducted in compliance with all relevant statutes and regulations. The HIPAA protected health information, PHI written consent information release of the employees shall be required for the release of information from their health file to the department. We're proposing streamlined language, saying record keeping will be conducted in compliance with all relevant statutes and regulations. And therefore, if there's anything else that comes into play when it comes to confidentiality of information or authorizations that need to be necessary, that this agreement stays in compliance with that. And
Is that it?
that's all.
Right.
And from our review, that's everything that we have now covered under employee handbook, management rights, and all others. That's everything except the economic items that we have listed, which are primarily in Article 8 and I think 1 or 2 in Article 9. That's all I have on the agenda for today, unless there's more discussion on any of those items.
But we do need to discuss what's on for the next agenda, right?
Yeah.
Okay. You ready to move to that conversation?
Yes, sir.
All right. You have anything in particular?
It sounds like we have the issues that pertain to,
Economic.
economic items. So is that what we want to talk about next, or do you guys have something else?
Well, I think we would really like to hear from, have an opportunity for discussion on the items that you proposed that were non-economic.
Okay.
And I would propose that we do that for the next meeting. I did do a draft outline that I would
Mhm.
hand out, and see what you think.
Did you make enough for the audience, or?
I'm not sure. I made probably 13.
Okay.
Can you pop that on the screen?
No, or maybe not. I don't know. Here.
Oh, I can do it on there.
Yeah,
On the Elmo, yeah.
yeah.
I'm good, thank you.
So I would, as we mentioned earlier, we, I think, would be prepared Friday to give you the exact contract language on some of the things that we had question marks on. And we had discussed that at the last meeting, that that would be helpful. And so, we're prepared to have that ready to go so that you have a complete list of our, of what we would, what it would look like in the contract. And then I would, as I just mentioned, really like to hear on your non-economic proposals and have an opportunity to discuss those at the next meeting. And I think that would clear just about everything in the agreement, and from my thoughts, everything in the agreement except the economic items, and that we would be, both teams be prepared to discuss those on, beginning next Wednesday, the 22nd. Would that,
Yes, ma'am.
does that sound okay?
Sound like a plan?
Yes, sir.
And I would be happy to list in the agenda the exact, like we've been doing here for the city sections. If you send me those sections, I'd be happy to put those in the agenda
Absolutely.
for next time. And then at the bottom, I listed our meeting dates again.
Yes, that's appreciated.
Anything else for the good of the order? We're done?
No, sir.
I think we're adjourned.
Okay,
All
great.
right, thank you.
Lloyd, do you have just a couple minutes? We can talk.